The William Ruto administration's commitment to respect for human rights once again came into question this week, following the forcible return of 4 asylum seekers fleeing political persecution in Turkey. Human rights groups point to a worrying trend of the Kenyan government kowtowing to strongmen and in the process eroding confidence in the country's willingness to keep refugees safe. What's in a name? Refoulement, reparation, deportation. Words whose meanings have come into sharp focus following the abduction of a British national and 7 Turkish nationals in a coordinated exercise a week ago.
A white jeep blocked our way, and in that car there were 4 armed people, and they pointed their weapons to us. They forced us to go with them. I realized that all of them was wearing a mask. They covered our eyes, and we were handcuffed.
It saw 4 of the 7 Turkish nationals who should have been protected by their refugee status returned to their country of origin from which they had sought asylum in Kenya. The Ministry of Foreign Affairs describing their return as repatriation and not refoulement. A serious breach not only of Kenya's Refugee Act, but the 1951 UN Convention relating to the status of refugees, the 1967 Protocol relating to the status of refugees, and 1969 OAU Convention governing the specific aspects of refugee problems in Africa. Kenya's Refugee Act of 2021 in Section 29 stipulates that no person shall be refused entry into, expelled, extradited from Kenya or returned to any other country or be subjected to any similar measure if, as a result of such refusal, expulsion, return or other measure, such person is compelled to return to or remain in a country where the person may be subject to persecution on account of race, religion, nationality, membership of a particular social group or political opinion, or the person's life, physical integrity or liberty would be threatened on account of external aggression, occupation, foreign domination, or events seriously disturbing public order in part or whole of that country. The Refugee Act does, however, include the following exception. The benefit may not, however, be claimed by a refugee or asylum seeker whom there are reasonable grounds for him or her being regarded as a danger to the national security of Kenya. Actions which have elicited concern not only from the UN High Commissioner for Refugees, but from religious leaders.
Ni mtindo ambao unaleta hofu nyingi na unaweza kuharibu sifa ya Kenya.
Civil society groups, legal practitioners, and even Kenya's partners.
Recently, there was the arrest of 36 Ugandans. Is Kenya safe for refugees anymore? Or if your government agrees with our government, you cannot enjoy the protection that refugees enjoy under international law?
Human rights groups view the return of the Turkish refugees as further proof that Kenya has no business serving on the UN Human Rights Council starting January. The return of the 4 Turks coincides with the death of Fethullah Gulen, a Turkish spiritual leader and Islamic scholar who founded the Hizmet movement and who was buried on Thursday in the United States, where he was in self-exile. Following an attempted coup in 2016, which Gulen denied any involvement in, his movement was designated a terrorist group, and Tayyip Erdogan, the president of Turkey, oversaw a crackdown on schools, media outlets and businesses associated with his former ally. On his death, Erdogan described Gulen as, quote, a demon in human form. All right, as promised, I have in a studio Dr. Edgar Githwa, diplomacy and security expert. We also have with us in a studio, who you saw in that report, Dimas Kiprono, Deputy Executive Director, the International Commission of Jurists, Kenya. And we also have joining us virtually, Irungu Houghton, who is the Executive Director, Amnesty International. Both Amnesty and ICJ released statements following this abduction of initially 7, 4 ended up being refoulement or repatriated, according to the Ministry of Foreign Affairs. Why did it trigger you to release a statement?
What triggered us is that the principle of non-refoulement is a basic tenet of international human rights law and international refugee law. This is the principle that protects the human dignity of any person who felt that they had to flee their country for whatever reason. And so when such person is then returned by a host country to that country that he or she fled from, it is a breach of international law, and we cannot secure their safety, their legal rights. And so we find that it is quite problematic. And it speaks to a pattern that may be worrying to many people. When a person flees their country and comes into Kenya, international law dictates that now Kenya has a legal obligation to protect them. We have a UNHCR office here that works together with the Kenyan government to ensure that any refugee or asylum seeker is processed. These individuals had been processed. Another tenet of non-refoulement and even extradition or repatriation is that repatriation cannot be done for political purposes. And from what we are seeing is that these people were taken back for political purposes. They were wanted by the Turkish government for political purposes.
But in a statement he posted to his social media handle, he said, Kenya, let me find this, that they have gotten a commitment from Turkey that these persons will be handled with dignity. Good enough in your view?
So how do you measure this commitment, especially since it is likely that they were taken because of political reasons, right? And even if you look at definitions of words such as terrorism or sedition or subversion, these are not very tangible, definable words. And so it leaves a really big window for abuse. And I think also what Kenya has done essentially is an invitation to treat to other nations. If you're powerful enough, we can talk. If your citizens are here, we can talk. Yeah, which is a very dangerous precedent.
All right. We talked about due process. What, Dimas, in this situation would have been due process?
Due process is set out within our laws and also within the procedures of UNHCR. So within our laws, Turkey would have put in a formal request to the government. Usually goes to the Ministry of Foreign Affairs, and then it's transmitted to the Attorney General. And that request usually has to outline the allegations, the evidence, the charges. And then whatever comes out there is then taken through a judicial process, right? And a hearing is had whereby those refugees are given a chance to defend themselves and say why they should not be taken. And they even have they have a right of appeal if a decision is not to their satisfaction. And this ensures that, first of all, that the reasons are legitimate, the evidence meets the threshold, and that whatever they are being charged with back home is also a crime in Kenya. So it has to be a crime in both countries, right? And so in this case, we did not have that opportunity for due process to continue. Another thing, when these matters are taken before a court or before the UNHCR, they look at what are the probabilities of that person being persecuted, being tortured in the in the country that they are being repatriated to or refoulemoed to, you know. And so these are the fundamental things that were not there. In fact, non-refoulement is even in the Convention Against Torture. It is in the African Charter. And so there's a litany of laws and principles that we have violated. Non-refoulement is a customary law. It has the status of customary law, meaning that every country in the world, in the community of nations, must respect it, regardless of even if they are part of treaties. It is customary law.
Okay, so just a quick follow-up to that. Is it a situation where the milk is spilled, or is there recourse?
How would you bring those people back? Yes.
Damage is done.
Yeah, damage is done. But there is legal recourse in Kenya. Yes, there are questions that may need to be asked for courts to interpret, or rights to see whether certain rights have been violated.
All right, thank you very much for speaking to us tonight, gentlemen. We've had in studio Dimas Kipruna, who is the Deputy Executive Director, International Commission of Jurists Kenya.